14C.
I've got 879.2, CTH memorandum to Eskom dated 17 February 2017.
891, Chair.
Yes, I know you said 891, but I'm saying that's the last page I have, and the next page is 951. Looks like there are some pages in between
Missing.
that are missing. And I don't remember that I may have taken them out.
Yeah, my junior says hers is also the same.
I've seen the continuation of Moody's affidavit.
The affidavit is missing there. Oh. Okay, it seems there's an overflow from 14B to 14C.
The bundle I have is 14C.
Yes, you have 14C.
Is it the correct one?
From my junior that 14B, right at the end of it, has the affidavit. Starting on page 882.
Well, I hope I didn't take the pages out to work on them and then forgot to have them taken back into the bundle.
Yeah, my junior does indicate certain pages are missing in both your bundle and her bundle.
Well, maybe probably the missing pages are in my residence.
Well, they're missing in hers as well. So,
oh, yeah, okay.
Yeah, we will have to do attend to.
Okay, I've got Moody's affidavit, but now it means we'll be looking at different bundles and pagination, or you'll use the paragraph numbers.
The page numbers are the same, I see.
Oh, is that
yes.
So? Okay.
My only concern is whether the annexures are going to be in the right place.
Is it not easier to quickly make copies of exactly the pages that are missing from the other bundle? Well, I don't know. I don't know where the earliest the nearest photocopier may be.
Yes, she's communicating with the bundles people.
Okay, maybe we can go on so long.
Yes.
Yeah.
So the page and paragraph I wish to refer to of this bundle is Eskom bundle 14C. I mean B. For you, Ms. Daniels, it makes no difference.
Okay.
It's page 891.
Yes, sir, I've got that page.
Yeah, paragraph 22. But the bottom line is this. Let me start with that. We can go into the details. give Chairperson a moment. Shall I proceed, Chair?
Does this make a lot of noise?
No, it's just that I want the Chairperson's attention.
Yeah, no, I was listening. Yes.
Because I want to lay the building blocks, and the Chair, I don't want to leave the Chair behind.
Okay, okay.
Yeah, I want to be on the same step.
Yeah, I'm happy that today you don't want to do that. All right.
Yeah. In short, Ms. Daniels, and before we go into the details, what we see from the concerns raised by the attorneys for Eskom, CDH, in the ultimate end, which leads to the amount being drastically reduced from 2.1 billion to actually 419 million, is a distinction between two periods. There's the penalized period, which is from March 2014 to May 20, it's March 2012 to May 2014. They call it the penalized period. That means, Chair, that's the period when Eskom had imposed penalties and deducted.
What's the period?
March 2012 to May 2014.
Yeah.
Now, they had deducted an amount of 158 million rand from OCM. But in that period,
1 second, Mr. Slugger.
yes, Chair.
Yes, continue.
So that period has, on the one hand, an amount that was actually deducted. This amount gets to be included in the claim. Then it becomes a double claim.
So an amount that was deducted from the claim.
It was deducted from, so it's imposed as a penalty.
Yeah,
and
withdrawn.
Deducted from the invoices. So,
yes,
yes.
Which means OCM paid.
That's right.
They paid the penalties.
Penalties in that period.
Yes.
To that amount.
Yes.
They still included it in the 2.17 billion claim.
Okay, and how much was that amount?
It's 158 million rand.
Okay, all right.
Now, Chair, let's see whether I can help you. I can talk. Yes. Chairperson, go to page 928 of Eskom Bundle 14, that affidavit of Mr. Motley. There's a table there with the figures. 928. Oh. There's the recording people, Chair, say, when you speak with a mask on, they don't capture
can't hear me. I thought they could hear me.
No, the sound system doesn't pick up.
Okay.
They might be able to hear you, but the technology fails to hear.
Okay, all right.
Yeah. So that table at the bottom of the page, Chairperson, That's a summary of this claim.
And
So the amount,
this table
yes,
shows how the settlement was arrived at, or shows
Yes.
something else?
that's how the settlement was arrived at, Chair.
Oh, okay, all right.
So you will see the amount I'm talking about is in the second row,
Yes.
which is less penalties already deducted.
Oh, from the 577,839,105.42 amount.
Correct, Chair.
Okay.
Yeah. So the 158 million rand had already been imposed as a penalty and taken off from OCM. But nonetheless, the executives within Eskom included it in the arbitration claim, thus increasing the claim to 2.17 billion. That's the one aspect. The other aspect, which is not apparent from the table, Chair, is what they refer to as penalties for sizing specification. So they're saying OCM, in that period of March 2012 to May 2014, you delivered coal that was not according to size specification. That penalty amount was 1.4 billion rand. But Eskom had problems with it, in the sense that in succeeding to prove that claim, because they had not complied with the agreement to notify OCM as and when the breach occurred that you have breached. And this is how we're going to calculate the penalty. If you do that, if you don't do that, then you are assumed to have accepted.
You are taken to have had no problem with the coal.
Indeed, Chair.
Yeah.
Indeed, Chair. And you will see.
So the failure to give that notice results in you being barred from raising a claim if you didn't give that notice within the time,
contemplated.
the prescribed time.
Yes.
Yeah, I remember seeing that.
Yes. And now this is 3 years later. This is in 2015, March 2012, March 2013, and then May 2014. 3 years later, CD8 says, these are the concerns. You might be taken to have waived your rights because you didn't invoke those rights. That 1.4 billion, Chair, they abandon it.
On that ground.
There's another
other
ground.
grounds. Okay.
There's another ground. But I think it's a cumulative effect of all these grounds. The other one, and you see this from the memos, Chair. The other one is that Eskom had agreed with OCM in 2015 on specifications, sizing specifications, that now matched the coal that OCM had supplied during the past 3 years. And once they did that, OCM says, so what's your problem? Why are you putting this in the claim? Because you have agreed with us and you didn't suffer any harm to your power station. So that 1.4 billion, which Eskom should have known, ought to have known, they had capitulated on it, but they still included it in the amount. So nothing then gets to be claimed for the period March 2012 to May 2014. Then there is a period from June 2014 to May 2015. Eskom again included a claim for sizing specification. That claim, Chair, had to be abandoned because of that agreement, because of not invoking the clauses that say you are in breach, we will impose the penalty.
Notification clause.
Correct. Yeah. And that amount was 744 million rand. What Eskom ultimately pursued against OC, now this is Tigeta. This is now in 2016, 2017. What they ultimately pursue against them and then are forced to settle, it's an amount of 419 million. That amount is penalties imposed only in respect of quality specifications. And then from that amount, you find the deductions on page 928 in that table. The total penalty is 419 million rand, and then there's less CV penalty, which is 126, so they are deducting from the amount two further amounts, 126 million and 37 million. And the amount ultimately is 255 million. Ms. Daniels, you followed that?
Yes, I did.
Now, ultimately, the attorneys for Eskom gave what I see from the evidence to be 5 legal opinions where they raise concerns. Could you comment on the correctness or otherwise of what I have explained to the chairperson in regard to how the amount was ultimately reduced? On the one hand, or first and foremost, but on the second or secondary to that, to explain to the chairperson why was the higher amount pursued despite the fact that the officials within Eskom ought to have known that they had already charged OCM in respect of one amount. Why are they double claiming it or sought to do so? And 2, why they sought to incorporate in the claim way after the fact penalties that they had failed to pursue during the first 3 years when the breach occurred.
Yeah, Mr. Chairman, I'm sort of, Mr. Tsaleka did a very good summary there, so I'm not sure how much I'm going to repeat when I say what I say, but you can guide me on that. It is correct what Mr. Tsaleka was saying about how this amount was arrived at. There are really those 2 factors, the double counting and of the 158 million, and the application of the sizing penalty, which in reality was not a penalty of such, but it was really supposed to be a payment reduction for coal received. The formula was set out in the first addendum to the coal contract, And it is correct that the attorneys, CDH, way back in 2013, had raised the issues that they raised, and both to Eskom's internal legal advisors and to them, and also to the executives responsible in primary energy, in generation, and also the chief executive. So in 2015, just before the decision to institute action, this would have been head of generation was Mr. Machela Koko, the chief executive was Mr. Brian Malefe, and I think the head of primary energy at that time was Mr. Johan Bester. I think he was acting. I seem to recall from his testimony that he did raise these concerns with Mr. Koko and Mr. Malefe. The attorneys have been consistent since 2013 in respect of three aspects. Eskom, in terms of its contract management procedure in primary energy, did not provide the proper notices, the proper contract management mechanisms to actually enforce the sizing issues, and in effect waived its rights by doing so. And you will see in the later opinions, Dr. Hofmeyer does talk about the argument for rectification because it seemed to be an unintended consequence. At the time, the issue when the first addendum was concluded, the issue was around sizing and the protection of, the right kind of coal going to the power station. So that was one issue. So the contract management, and that is consistent throughout, that they say, even in the opinion that I asked for in late 2016, they do say that this is an issue that we have in terms of we do not have sufficient evidence to prove that we had invoked our rights, and effectively we had then waived them, so we could not enforce them. The methodology in terms of calculating the other payment reductions was also inconsistent. So that is why you have the quality issues that we have. The unintended consequence of the sizing formula that we had was that certain quality parameters were then not penalized, and that was another issue that Kafteka raised. And this was not the first time that this issue was raised in 2016 when the opinion came. If you look at the 2013 opinions that Mr. Seleka mentioned, 2015, you will see that those issues are there. The issues have been consistent throughout. And last but not least, there was also an issue with the manner in which Eskom was sampling the coal. And a further issue was that Optimum did raise that they were not able to meet the sizing requirements, and that the parties then entered into negotiation. And effectively what that negotiation did was then suspend the sizing payment reduction mechanism. So this was, I think you would see it in the documentation around 2014, 2015, when Glencore Optimum said that they would need to renegotiate that. That was part of the cooperation agreement. Now, this was presented to the primary energy people, and it was presented to Mr. Koko and Mr. Malefe at the time. And they, notwithstanding these procedures, insisted on going ahead and claiming the 2.1 billion. Effectively, Mr. Chair, if you took the sizing, if you included the sizing penalty, it took the amount up to 2.1 billion. If you removed it, it was at the 419 mark. So I think there were all those factors, but Mr. Koko and Mr. Molefe insisted on proceeding with the summons, and you will see that when Cliff Decker Hofmeyer issued the letter of demand, they do say that this issue needs to be further investigated and what's
I think
Looks like there's been an interruption.
yes. Looks like.
word. Not Mr. Thaker, does that cover?
Well, you disappeared, not in terms of your picture, but your voice. We couldn't hear you for a few seconds, maybe 10, maybe 15, I don't know. So we didn't hear you. I think maybe you need to start that answer afresh.
We lost the signal, Ms. Daniels, when you were talking about CDH sending a letter of demand and they said something further work needs to be done.
Okay. In the letter of demand, when the instruction was provided, this was in 2015, Mr. Chairman, the instruction was provided that that they need to issue the letter of demand. They did indicate that further work needed to be done on assessing the claim, because effectively what the sizing provisions in the first addendum did was if they were not enforced by Eskom, they actually fell by the wayside. So effectively, like Mr. Seleka explained, they were waived. I think in terms of the agreement, it actually says that the coal, it's not a waiver in the traditional sense, but the coal had, in the event that Eskom does not raise objections, the coal is accepted to have met the quality specs. And CDH indicated that we would have to investigate if that is so. You know, there wasn't enough paperwork at the time, and this was presented, this fact was presented to the executives at the time, and they decided, notwithstanding that, to pursue the claim as instructed.
Yes, thank you. Chair, if we take it step by step, and we start on bundle 14, page 891, paragraph 22. So with that background in mind, we go back to October 2013. Ms. Daniels, you got the page?
You said 822.
891. 891. Eskom bundle
yes.
14, yeah. Paragraph 22. So during October 2013, CDH provided a legal opinion to Eskom relating to the potential penalty claim on the sizing quality parameters under the CSA and addenda thereto, including our preliminary concerns relating to the evidence which would be necessary for such a claim to succeed. And they refer to C item 11 of the bundle. Chairperson, that's the opinion. It's on page 984. Well, let me read further here before we go to it. It says, pursuant to this advice, 984, Chair. The same bundle. Is it? No.
I don't think I've
No, that's where the overflow comes in.
I don't think I've got 980 something. My last page is 950.
Indeed, Chair. So that's where we overflow to the next. On 14C. 984.
Yeah.
Yeah. That is a memorandum on page 984 from Cliff Decker Hofmeyer, dated 23 October 2013, addressed to Mr. Johan Bester. And Chairperson, in this memo, they will then raise the concerns which they refer to in the affidavit.
Yes.
So I will confine myself for present purposes to the affidavit. Well,
am I right to suspect that we might be using this bundle for some time?
Yes, Chair.
So I can get rid of the other two that I've got here.
Yeah.
For now.
Yes, Chair. Yes, Chair. B and C. That 14B and C go together, Chair, and I'm sorry you don't have space there. Because the affidavit is in B, 14B, and the annexures are in 14C.
You can see, Ms. Daniels, what they are doing to me.
It's terrible, and this is quite, it's quite complex, Mr. Chair, and to navigate between the two, I do feel sorry for you. I will try my level best to keep it simple.
Yes, okay. I'll keep all the files here.
Yeah.
Okay.
So, if I may just pick up on certain points in that memorandum of 23 October 2013. And this is under the heading coal quality. So that's quality specifications on, it's paragraph 4. And they first set out how you should impose a penalty. In paragraph 4.2, 4.2.1, 4.2.2, and so on. So if you want to claim, as Eskom, a penalty for coal that doesn't comply with quality, you need to invoke those provisions. So Eskom had failed to do so. And then you go to paragraph 4.4, Chair, on page 985. They say, however, the apparent abolishment of Eskom's right, and I think this is the abolishment Ms. Daniels was referring to. Ms. Daniels, you will explain that, to an outright rejection of payment for coal, which fails to comply with the volatile quality parameter, may well have been an unintended consequence of the amendment of the CSA. Ms. Daniels, are you able to explain that statement?
I will try to explain it in simple layman's terms.
Well, let me express my understanding of it, and you can comment on that.
All right.
The way I read it, or I understand it, it seems to me that the CSA was subsequently amended. And with that amendment, Eskom's right to refuse to pay for coal that is non-compliant with quality specifications was abolished, or it was deleted, taken away.
It was essentially, with the first addendum, it was taken away if Eskom did not follow the procedure set out as they set out in 4.3. So yes, it was an unintended consequence. The reason for that, Mr. Chair, was that in a previous arbitration, Eskom lost the case because the arbitrator felt that we could not pay for coal that we had burnt, because it had already gone through. Because the issue here is that the quality results would only become known once Eskom had burnt the coal. You know, it's gone through the power station. So the argument was that we had had the benefit of using the coal, even if it was at a lower grade, but we had burnt the coal and therefore we had gotten value for it and we ought to pay for it. And in the first addendum, that was the reasoning that led us to put the sliding scale for qualities. Volatility is one of those issues that it needs to allow the coal to ignite and spark, and this was an unintended consequence that the attorneys picked up. But in the overall picture, it wasn't really an abolition of the penalty regime, because we made it more equitable for both supplier and Eskom. That was the rationale at the time. And I think these are the problems that the attorneys picked up as the application of that provision.
Yeah, it's hard to follow that explanation. But anyway, they say it may well have been an unintended consequence. Then they go further to say the nature of the volatiles of coal is that should it exceed the prescribed range contemplated in clause 4.4.1 of part 2 of schedule 1 to the CSA, it is relatively incombustible and of no or little use to Eskom. That being the case, Eskom may want to consider bringing a claim for the rectification of the CSA and addenda in order to ensure that the intention of the parties is correctly portrayed. As the CSA with the first addendum thereto currently stands, Eskom's remedy for coal, which does not meet the volatiles quality parameter, is limited to the payment reduction contemplated in clause 3.6 of the first addendum, and the other remedies provided, bracket specific performance, close bracket, therein. Now, then they go on to say, provided that Eskom has evidence of the people who negotiated the first addendum available to prove the common mistake, and that the arbitrator shall rectify the common mistake of the parties. Now, there's two things. Firstly is whether, if the amendment brought about an unintended consequence, the attorneys are saying, you will have to bring people who negotiated that amendment to come and show that this was indeed a common mistake between the parties in order for you to succeed with a rectification remedy. Is that a correct understanding?
That's correct.
Yeah. So you will need the evidence of the people who negotiated. On the other hand, they say the remedy available to you under the circumstance, in the present circumstances, is what is contemplated in clause 3.6, which they set out in paragraph 4.2 in the previous page. Is that correct?
I'm just reading. Yes, that's correct.
Okay. And then in terms of clause 3.6, this is what Eskom needed to do. 4.2.1. In the event that any quality parameter is not met for a 3-day rolling period, no adjustment shall be made to the purchase price. So you pay the full purchase price.
Yes, that's correct. Even if there was an issue
Yes.
with any of the quality parameters. But this would imply that Eskom kept proper records.
I see. That's the first 3-day rolling period. Let's go to the next one. 4.2.2 says, in the event that any quality parameter is not met for any 4-day rolling period, so in the period of 4 days, you have failed to meet the quality spec, then Eskom shall only pay 90% of the purchase price for such coal.
That's correct.
But then again, it requires you to monitor the situation.
Yes, it requires, and that's why the integrity of the sampling process that you will see CDH talks about later on was so paramount, because in order for this to work, Eskom would have to have records of daily, if not hourly, monitoring so that we could have a proper average.
Yes, and it goes on like that to to the next page, paragraph 423. If after 5 days, the supplier is supplying coal that doesn't meet quality specification, that Eskom has an entitlement to pay only 75%. And if it's a breach over 6 days, then they only pay 50%. If it's a breach over 7 days or more, then it's calculated differently.
Yes.
The purchase price shall be reduced to R1 per ton.
Yes, that's correct.
That's on quality. But Eskom had not invoked this clause.
No, it had not.
And that red flag is raised way back in 2013.
Yes, it is. And it's repeatedly raised it's consistently raised in CDH's communication with Eskom.
Yes. So it's a bit of a technical territory. And I'm trying to move slowly.
Yeah, no. No, I understand.
Yes.
It needs
careful consideration,
patience.
Yeah.
So, yeah, no, that's fine.
That's why I thought I would start with the bottom line.
Yeah.
And then we can build up the picture from there.
No, that's fine.
Yeah. So that's on quality. On sizing, that's quality specifications, because there's two specs, Chair, we are dealing with here. There's quality and size. Size comes on page 986.
Yeah.
Yeah, that's risk for Eskom on the imposition of payment reduction for coal which fails to comply with sizing specification. Risk for Eskom. Now they're going to set out the risk. And they say in paragraph 6, one of the major concerns Eskom has raised is the apparent failure or refusal by OCM to supply and deliver to the Eskom Hendrina power station coal which complies with the average monthly size distribution contemplated in clause 3.4.3 of the first addendum to the CSA. The apparent failure or refusal by OCM to supply. Eskom has not imposed any penalty or payment reduction for the continued failure by OCM to supply and deliver to it coal complying with the sizing specification, but now it intends to do so. However, during the past few months, a number of issues of concern have been raised. Should Eskom decide to impose the payment reduction for the period May 2012 to date? These concerns are inter alia the following: the credibility of the sampling process used to analyze compliance with the sizing specification of the coal supplied and delivered to the Hendrina power station by OCM, which OCM has placed in dispute. And Chairperson, then they explained that, and what's important is what you see on the next page, page 987. That paragraph at the top of the page, I want to read, to capture it there where it says, the 3 lines to the bottom of it. However, of concern for Eskom should be the statement made in its internal report titled Hendrina Hammer Sampler Audit, dated 7 June 2013, as prepared by Mr. Kulekani Dladla, which records the following about the current sampling process. The hammer sampler misalignment is the major concern with regards to the reliability and representativeness of sample issues experienced with the hammer sampler. The original equipment supplier must be contacted in order to repair the misalignment of the hammer sampler. The sampling system can then be audited again once this issue has been resolved. Ms. Daniels, can you explain that? That concern?
In essence, Eskom was not able to sample properly at that stage, Mr. Chairman. It was defective, the sampling system, so it was riddled with errors.
So, in other words, whereas Eskom was now intending to charge or to impose a penalty for quality that did not comply with sizing specification, Eskom had, the attorneys were identifying that, but you do have a problem in that intention or in that pursuit because your sampling process is not in order.
Well, Mr. Seleka, I would put it a little bit strongly if I remember what was happening at the time. I think the sampling system, not that CDH was saying we have a problem, I think they were saying that we can't actually prove our case.
I see.
Until we fix the hammer sampling process, and that was an issue at the time, you know, that we would actually not be able to prove reliably that the supplier failed to meet the sizing requirements.
Yes. Thank you. Chairperson, there's further
I'm sorry.
details.
Ordinarily, how would you prove that the sizing requirement had been met on normal circumstances?
Standard operating procedure, Mr. Chair, there would be a sampling process determined at a determined timing period. This was on a conveyor into the power station. So there would be samples taken at different parts of the conveyor that will then be taken to a lab, and there would be a composite sample tested, and those results would be made available to both the supplier and to Eskom. What was happening here was that the the hammer sampler was not taking regular samples. It was not taking comparable samples, like for like sizes. So the test results were always in dispute.
Okay, thank you.
Yeah.
So the problem was that you had no records to prove the results of any testing that may have been done, or the testing had not been done, hence you didn't have the records.
Or if the testing was done, the records were faulty and not consistent.
Yeah, okay.
Yes.
So it was effectively Eskom's own failure to do what they were supposed to do.
Yes, at that time, and
that time.
Yeah, it was a mess, if I can use that word.
Okay.
Ms. Daniels, where were you at the time, October 2013?
I think I was in group commercial.
Yeah, that's a very broad question. What was your position at Eskom at the time?
I think I had moved from primary energy to the office of the group executive, or the chief commercial officer. So primary energy was one of the divisions.
Yeah. So this. Yeah, just go ahead. I'll ask you.
Okay. So yeah, I had, Mr. Chair, the familiarity with some of the the operational issues with Optimum is because Optimum was one of the first contracts that I managed when I got to Eskom in 2006. So when it was first sold to by BHP Billiton to Optimum, I managed the due diligence process. So I do have a little bit more insight than what is normally, what's the word, expected of like a lawyer or something, because I worked on the operational side at that time.
Okay. So there's 7 more points. And
yeah,
you will tell me how much detail should be laid on the table here.
Well, continue, let's see.
Okay.
Yeah.
So that's on specific sizing spec, that's the first concern under 7.1. Then you go to 7.2, the attorneys are raising another point of concern. And they say the contention by OCM is on page 987. The contention by OCM that the sizing specification contemplated by the first addendum is no longer properly and/or realistically representative of the coal which the OCM colliery could reasonably be expected to achieve from exploiting the coal deposits constituting the Optimum colliery. Ms. Daniel, are you able to explain that?
What it meant, Mr. Chair, is that the sizing specifications as set out in the first addendum, the supplier could no longer meet.
So is it an impossibility of performance?
That's the legal term, that's correct, Mr. Seleka. What that then meant is, in terms of the agreement, the parties needed to renegotiate the sizing specification.
Which is
And
what?
during that,
Sorry, I interrupted you. Proceed.
and during that period, then the sizing price reduction formula would not be applied.
Yes. And we see the renegotiation on the next page. Page 988, paragraph 7.2.2.
Yes.
Says,
So-
let me read it. Eskom and OCM are also currently renegotiating the sizing specification. Should Eskom impose the payment reduction, this could potentially be used against Eskom. Should it be established during a dispute resolution process relating to the sizing renegotiation that it is not realistically possible for OCM to supply and deliver the sizing specification contemplated by the first addendum. You may comment.
That is what I was talking about. So during that period when there was the renegotiation, those provisions that you read out earlier, Mr. Seleka, would not apply.
I see.
Yeah, that is how it's written in the first addendum.
Yes. Then there is paragraph 7.3, 7.4, and 7.5, which raises further concerns. 7.3 says the risk that should Eskom set off the payment reduction for OCM's apparent failure to comply with the sizing specification, OCM will attempt to terminate the CSA on the basis that Eskom is not entitled to impose the prepayment reduction, inter alia for the following reasons. The sampling process used to determine the payment reduction is not credible. So I think this goes back to the HEMA sampling tool.
That is correct.
Yeah.
So combining that we did not have a credible sampling process with the fact that we are now renegotiating the sizing issue,
Yes.
meant that Eskom could actually not apply the payment reduction provisions in the contract. And what CDH is saying is that this would give the supplier, if in the event that we should apply the payment reduction mechanisms, that it could lead to the supplier cancelling the contract.
Yeah. I think you've touched on both 7.3.1 and 7.3.2. I mean, if you're busy renegotiating, why would you set off, deduct? And they say that would be a bona fide conduct. I mean, a mala fide.
Mala fide conduct.
That's right, not justified and not bona fide.
And that also led to the double counting that you referred to earlier, Mr. Seleka.
Yeah. Then 7.4 says, the risk that the payment reduction could be deemed as an excessive penalty stipulation in terms of the Conventional Penalties Act 15 of 1962. No documents have been provided which reflects the financial loss or damage to Eskom to date, or in the medium to long term as a result of OCM's failure to comply with the sizing specification. Well, that speaks for itself, isn't it?
Yes, that is what I was trying to explain earlier with the earlier arbitrations that we had, where the arbitrators would say, but you can't prove damage to your power station, yet you've burnt the coal.
Yeah. 7.5 says, Eskom has waived its rights to impose and subsequently enforce the payment reduction for certain of the months OCM failed to supply and deliver coal which complies with the sizing specification due to Eskom failure to inform OCM of the payment reduction and calculation thereof timeously as required by the terms and conditions of the CSA, read with the addenda. I think that too speaks for itself.
Yes.
Okay, that concludes the concerns in regard to sizing specification. Now, back to that background Chairperson I sought to paint. The penalty for sizing was a huge amount of the 2.1 billion. It was a huge amount, 1.4 billion. And because of these reasons, Eskom couldn't pursue that claim. But what it means is, Ms. Daniels, this claim could never have been pursued in the first place.
Mr. Chairman, that is correct. It was essentially a paper exercise.
Yeah.
And the purpose being?
Well, I think the purpose here was to at that stage it was Glencore. Glencore had come with, because they owned Optimum at that stage.
I thought that you didn't want, Eskom didn't want, Glencore didn't want a renegotiation. They wanted to pin Glencore down to the terms of the agreement, or is that much later? Is that a different time? Is that a different time? I may have missed something. I know that Glencore sought a renegotiation of the coal price in terms of the agreement, and that was during, well, even before Mr. Brian-Lefe arrived. But when he arrived, he was rigid that that would not happen, and he admits that. So that's not the time you're talking about.
My apology, Mr. Chair. I made a mistake with the timing sequence. This is 2013.
Yes.
When this first opinion was arrived at.
Yes.
In this time, there was still the cooperation agreement being negotiated.
Okay.
Yes.
Okay.
Okay.
All right.
So I think it's just to put it into context.
Okay.
At this point in time, there was still a good relationship with the supplier.
Okay.
But the supplier had already indicated hardship, which was one of the provisions in this cooperation negotiations.
Okay.
And this is why these issues were asked of the attorneys to opine on.
Okay.
Yeah.
Mr. Slager?
Yes, indeed, Chair. The cooperation agreement was concluded on the 23rd of May, 2014. So the following year, the cooperation agreement was concluded.
Okay.
Which gets to be terminated only in 2015.
Yes.
Yeah.
But what precisely did Eskom in 2013 want the renegotiations of the agreement to be about? Ms. Daniels?
From my understanding, Mr. Chair, it was the coal quality issues were raising its head again, notwithstanding the amendments to the contract in terms of the first addendum.
Yeah.
And the supplier already was having issues meeting the sizing, which was a big issue for Eskom. And that is where these issues started. But I must give you context that this has always been an issue with Optimum, and it required close management from both parties' side.
Okay, all right. Mr. Saleh.
Thank you, Chair. Chairperson, I see is about 6:10. Should I pace myself to finish by 6:30? Or to stop?
Let's pay, well, put it this way. If you are not done at 6:30, and there are still important issues,
Okay.
we can look at adjourning for the day and then finding another hour or whatever. If Ms. Daniels would make the time, I'm sure she would make. It's a question of what date.
Yes.
I am aware that on Tuesday evening I've got an evening session, but I don't know whether you and I already made any arrangements for an evening session on Monday.
No.
If we haven't, subject to Ms. Daniels being available, we could try and finish with her on Monday.
Yeah, the Monday witness is Mr. Kokoche.
Yes.
So
you think we might need to go into the evening with him?
we can't put anybody in the evening there.
Eh?
We can't put anybody in the evening. It's a huge risk.
But we could try and find some time one of the evenings next week.
Yes.
Does that
That will be
sound
okay.
more or less so fine with you, Ms. Daniels?
Yes, Mr. Chair, that will be in order.
Okay, all right. So I think let's continue until 6:30,
Yes.
and then we can adjourn and continue on some evening next week.
Yes. Yes, Chair. I will tell the person at the end. So, Ms. Daniels, then, those are the concerns.
I wanted to ask you, Mr. Silega, was whether there was, you were moving away from that opinion without going to the conclusion thereof deliberately.
No, I'm not moving away yet.
Oh, okay. I thought you were moving away. Okay.
No.
All
There
right.
is the last point on quantity specification. The last point on quantity, Ms. Daniels, that is raised immediately after paragraph 7.5. You see the heading in respect of coal quantity.
Yes, that's correct.
You see that. But what they do first, paragraph 8, 8.1, 8.2, 8.3 to 8.4, they set out the terms of the contract. And the concerns are raised then on the next page, page 989, under the heading Conveyor Availability Dispute. Paragraph 8.5 then reads, Eskom's right to impose a penalty for short supply of coal has also been disputed by OCM on the basis that Eskom is not entitled to impose a penalty for short supply due to the unavailability of the conveyor system operated by Eskom. 8.5.1, OCM contends that its failure to supply and deliver the required quantity of coal per month is directly linked to the unscheduled stoppages of the conveyor system by Eskom. Eskom has disputed OCM's contention that unavailability of the conveyors is directly as a result of Eskom's conduct and reserved its rights to claim the penalty pending the finalization of the dispute relating to the conveyor availability. It will need to be considered, paragraph 8.6, it will need to be considered whether the dispute relating to the conveyor availability should be joined with the hardship arbitration and future dispute relating to the entitlement of Eskom to impose the payment reduction. Ms. Daniels, I've had the benefit of going through all of this memos and all the way to the end of the settlement. And I have struggled to find a penalty being pursued by Eskom in regard to short supply. Your comment?
Mr. Seleka, based on what I've seen from the documentation, Eskom in the first instance reduced the supply, the quantity in the first addendum to not the 5.5 million tons. It was reduced. There's a figure in there. And always the issues around the conveyor availability made this very difficult for Eskom to actually impose the penalties, if not impossible, because it was always on the back foot in terms of it not performing 100%.
Yes, because, well, that's fine, but you will recall from the settlement that ultimately the penalty that was pursued and on the basis of which a settlement was concluded related only to quality. I don't know whether you can recall offhand.
I can't recall offhand, I would just have to look, but quality, that was the only aspect that we could actually prove on a balance of probabilities.
Yes. Then, Chair, the conclusion then follows after that, and it's a summary of what we have traversed. Should I read it to the record, Chair?
Well, not necessarily, if you don't think there is any significance to it for your purposes.
Yeah, I think the points raised in the body of the memorandum covers the issues.
Okay.
Which are then summarized in the conclusion. So let's go back to Mr. Moodley's affidavit. And that paragraph 22.
Are you going back
to the affidavit, which is in 14B, at the end of 14B. Page, for your purposes, Ms. Daniels, is page 891.
Thank you, Mr. Seleka.
We were at paragraph 22.
Okay. So you said you are going to bundle
14B.
14B.
Page 8.
Moodley's affidavit.
Yes, Chair.
And paragraph 22, you said?
22, yes, which is on page 89. 891. Oh.
Okay, I've got it.
Thank you. So we had read the first part of that paragraph until item 11 of the bundle, which is what we were reading. But let me read it again. So during October 2013, CDH...
Sorry, Mr. Seleka.
Yes.
I see that you're going back to this affidavit at 19 minutes past.
Yes.
If you think we can make use of the next 12 minutes or 11 minutes effectively, we can continue. But I'm thinking just in case you are starting something that might be better started when we will have more time.
Oh.
But if we can make use of it, we can make use of it.
I hear the chairperson. I think I will end with this paragraph.
Okay.
Because the next thing is the second opinion.
Okay, no,
And
that's
that
fine.
requires a time of its own.
Okay, no, that's fine.
So, so the paragraph, let me just read this. It said, during October 2013, CDH provided a legal opinion to Eskom relating to the potential penalty claim on the sizing quality parameters under the CSA and addenda thereto, including our preliminary concerns relating to the evidence which would be necessary for such a claim to succeed. And then they refer us to that opinion which we've read. Ms. Daniels, you follow?
Yes, I'm following.
Pursuant to this advice, an extensive exercise was embarked upon in order to consider and review the methodology Eskom needed to apply, or should have applied, in calculating the penalties for various coal quality parameters under the CSA. The reason being that Eskom itself was unclear as to how the penalty regime contained in the first addendum to the coal supply agreement should be applied. You see that?
Yes, I see that.
So it begs the question, how does one then adamantly say, or forcefully say, OCM needed to pay us 2.17 billion rand, when you as the claimant don't even know how to arrive at the amount? Do you have a comment?
Mr. Seleka and Mr. Chair, this was, I mean, in 2015, when the decision was made, the executives did not listen to any reason. They were determined to go ahead, and notwithstanding these flaws, which actually didn't get any better, they persisted with the claim and actually, I think, excluded for a time period even the internal legal departments from the discussions with the supplier.
I'm not sure if I understand that. Mr. Selaga's question is, how do you proceed or pursue a claim against somebody in circumstances where you are not clear as to how to apply the agreement on which the claim is based? I think that's the question.
Correct.
So the least that can be expected is that if you pursue a claim based on an agreement, you know, at least you should know how to apply that agreement or that claim in terms of the agreement. So if you pursue it in circumstances where you are unclear how to apply it, it calls for an explanation. How do you do that?
But you would have to.
Are you able to throw light on that?
I'm not able to throw light on that, Mr. Chair, because I was not there at the time, but you would have to ask Mr. Molefe and Mr. Koko for the basis on which they made those decisions, because you will see from the evidence that, you know, the advice did not change.
Yes.
And you will see later on
Well,
that
Mr. Molefe
even...
wasn't there, So maybe, Mr. Koko, 2013, Mr. Molefe wasn't there, isn't it?
Yeah, but what happened in 2013, you'll remember they did try and do the cooperation negotiations. That was from 2014 onwards. So there was work done, and they went into primary energy and Glencore, Eskom and Glencore went into these discussions, and they were quite extensive. And that is how they ended up with the increased price.
Yeah. So to explain it properly, Ms. Daniels, then you will say yay or nay to this. So, Chair, in 2013, the parties are still negotiating what culminates into an agreement in 2014. There is no claim yet, but CDH is engaged to advise on what is potentially a claim. The agreement is meant for the parties to cooperate to reach a commercial, amicable agreement going forward. That agreement, which would have then changed the main agreement between the parties, the co-supply agreement, was terminated after Mr. Molefe comes there. And that's when the penalties then are sought to be enforced. And that happens on the 22nd of June, 2015. And so then that question arises, given all this information given to you already in October 2013, how do you, with a clear mind, a clear conscience, pursue that claim when this information is already given? And that question arises at that stage. And on that note, Chair, I think I will pause there because we will be then going into the second leg of this exercise, which is just as detailed as the first one.
Would your estimate be that we might need an hour or 2 hours?
2 hours.
2 hours?
2 hours.
Okay, all right.
Yeah.
And would it not be better that Ms. Daniels should have completed her evidence before certain witnesses testify, such as Mr. Bramlefe? Or not necessarily? I'm thinking about not necessarily.
I think not necessarily, Chair.
Okay, no, that's fine.
I have mulled over that.
Yeah.
But because of the opinions which we rely on in Mr. Moodley's affidavit.
Yeah. Okay.
Yeah.
No, that's fine. The missing pages from one of the bundles that we were talking about, I would be glad if...
Okay. Chair, it's sorted.
It is sorted.
It is sorted.
So, okay, all right. So if that can be included in the bundle, then as soon as we adjourn, and then Registrar, I would like you to make sure that the protectors will know which bundle that is.
Yes.
So that they can show it to me later on which bundle that one is, which had missing pages, which will now be inserted, I guess. I do suspect now that I did take out the missing pages to read them some time back, and I suspect that they were not taken back, and I should have them
We'll double
at
check.
home. But because those have been prepared, they can be put in. I may have made some notes on those ones, and if so, I will just replace them.
Okay, I will check your function.
Okay, all right.
Chairperson, may I bring to your attention the following in regard to Mr. Anod Singh?
Yes.
He has brought an application, or is bringing an application for a postponement. I saw the email during the lunchtime, so they've printed out a copy for me. The chair will remember that he's scheduled to testify on the 3rd of March, which is next week, Wednesday. So maybe we need some direction in regard to whether they should come to argue this application before the chairperson, because summons were issued for him to appear.
Yeah, well, they'll have to do that.
Okay.
And it shouldn't be, it might be late. It shouldn't be argued on the day he's supposed to be here. It should be argued before.
Oh,
so that if it's granted,
yes,
maybe the day could be used
for
another witness.
Indeed.
But I will read the application. I'm not aware of it yet. Or it has not been launched? Or it has been launched?
It has been.
Or it's still on the way?
No, it is here. I can hand up a hard copy.
Yeah, no, don't hand it up. It should be sent to me.
Okay.
In the other way, other than handing it up.
Okay.
Yeah. Okay, next week I'm continuing with Eskom-related evidence, and the witnesses that are lined up. Who is testifying on Monday?
It's Mr. Koko.
Mr. Koko Tuesday.
Mr. Brown Molefe.
Yes, and Wednesday is supposed to be Mr.
Anod Singh. And then on Thursday is Miss Bianca Goodson.
Yeah. And Friday is Miss Brown not coming next week? The former minister.
No, I think Eskom has only 4 days next week. Yeah.
Is that so?
Yeah.
But is there another day where Ms. Brown has been put in? Because I was under the impression during March.
Yeah, no, I'm not aware yet.
Yeah, okay,
yes.
All right. Okay, that's fine. So that will have to be done. She will have to be scheduled to give evidence because she has to deal with some important issues.
Yeah.
So after next week, if all the witnesses that you are lined up for next week, they are all done, you would be left with Ms. Brown and how many others?
There's Minister Zwane as well.
Oh, and Minister Zwane.
Which we intend calling.
Yeah.
Mr. Romeo Kumalo.
Yeah.
And the chairperson has made a request for, well, it has to be finalized with you, Chair. Mr. Eric Wood.
Oh, yeah.
Mohammed Bobat.
Yeah. Yeah, okay, no, that's fine.
Yeah.
Okay, so just for the public, so next week we'll be continuing with Eskom-related evidence. Okay, we are going to adjourn. So Ms. Daniels, the legal team will be in touch with you with regard to an evening session next week.
Thank you, Mr. Chair.
Yes. Thank you very much. We adjourn.
Thank you. Suzanne?